Good morning, good afternoon, and good evening, everyone. Welcome and thank you for joining us from across the world. It is a pleasure to welcome activists, community organizers, lawyers, diplomats, UN colleagues, and allies to this important conversation. Yes, Daniele, merci. Voilà. Thank you. Pour ce bonjour à toutes et à tous, entre les deux et au-delà des barrières du genre, pour
Good day to everyone.
le webinaire sera
The webinar
en anglais.
is going to be done in English. There is simultaneous interpretation in French. You can choose your preferred language by clicking on the three dots below. We've got
circulaire interprétation, donc vous choisissez le français ou l'anglais.
Click on more, then interpretation, you choose your preferred language, to French or in English.
I hope that everyone now has the translation. So we begin from a position of clarity. Decriminalization is a human right imperative. Laws that criminalize consensual same-sex relations violate human dignity and fuel violence, discrimination, and exclusion. Today's discussion is not about whether decriminalization should happen. We all share that goal. Our discussion is about how we achieve it, who leads it, and how states and the United Nations can support communities without causing harm. As Frantz Fanon wrote, each generation must discover its mission, fulfill it or betray it. As an Algerian, those words resonate deeply. Our struggle against colonialism taught us that freedom cannot be imposed from outside, even with good intentions. It must be built by the people whose lives are at stake. That is why our guiding principle today is simple: nothing about us without us. Communities living under criminalizing laws are not the beneficiaries of this movement. They are its leaders. This webinar is organized by Jin Soji together with Outright International, ILGA World, the International Service for Human Rights, and other partners. We have organized this conversation because this is a defining moment for our movement. As discussions continue around possible action at the UN Human Rights Council, organizations from criminalizing context have consistently called for one thing: meaningful consultation and community leadership. Today is an opportunity to listen to those voices, learn from different regional experiences, and explore how international solidarity can strengthen rather than unintentionally undermine local efforts. Before we begin, a few housekeeping announcements. The webinar is taking place in English with French interpretation available. If you need interpretation, please select your preferred language using the interpretation button at the bottom of the Zoom screen. We apologize that the Deep L voice is unfortunately not working with Zoom webinar. We regret the inconvenience and appreciate your understanding. Please keep your microphone muted unless you are speaking, and use the Q&A function to submit your questions throughout the discussions. We will address as many as time allows. It is now my pleasure to introduce our moderator, Arvind Narain. Arvind is one of the world's leading human rights lawyers and scholar on sexuality, gender, and constitutional law. He played a pivotal role in the movement that led to the repeal of Section 377 in India. and has spent more than 2 decades advancing equality through law, advocacy, and community leadership. Arvind, thank you for being with us today, and the floor is yours.
Thank you, Yahya, for that very kind introduction. It's my absolute pleasure to be here to moderate this very, very important discussion and conversation looking at the question of decriminalization led by communities and what states and the UN can do to support this particular issue without causing any harm. Again, as Yahya indicated, we're all very committed to the entire issue of decriminalization. And again, if we ask the question why, we understand that decriminalization is a harm, or criminalization is a harm of a very high order. In the sense that what criminalization does is it impedes your right to live with human dignity. And I think nobody said it better than the Botswana ruling, where they made the really beautiful point saying the anti sodomy laws deserve archival mummification, or better still, a museum peg, shelf, or cabinet for archival display. And the Indian ruling in Navteej Singh Johar again made the point that the question of criminalization deserves an apology from the courts, because criminalization again interferes with your right to live with dignity, because dignity includes your right to make choices about your personal intimate life, and among the most personal and the most intimate choice people can make is over the person they choose to be with. And that's a very deep level of harm. And obviously, in terms of the LGBTQ movement over the years, it's been a very central and very pivotal issue we've all been very committed to in terms of the battle or the struggle for decriminalization, which we've had a number of victories. But at this particular moment, the question which we're discussing is what is the best way to achieve that wanted outcome of decriminalization? And the reason we have concerns around this is we have realized, again, if you go to the entire the preamble or the preamble of paragraphs to the mandate of the independent expert, the idea is you take forward human rights in an interrelated, interdependent, and indivisible manner. You understand that the rights on sexual orientation and gender identity are not divorced from the societies we live in, that they're deeply connected to structures of racism, they're deeply connected to structures of inequality in the societies that we live in, including the inequalities between the global north and the global south, which gets you to the central question, the question of criminalization. The question of criminalization is really a legacy or a gift of the colonial powers. It's a gift in particular of Britain and France to all our countries in the global south. And now we are engaged in this battle to get this criminal law off our backs. What is the best way we can get this criminal law off our backs is the question. And the environment we're speaking in today, again, it's very, very important to contextualize it, is the environment living in today is an environment that is deeply unfriendly as far as human rights are concerned. We know that the UN mechanism is under attack on many, many fronts. And we know that the entire question of colonialism has resurfaced in a very big way as a form of neocolonialism as far as the global order is concerned. In that particular context, how do we take forward the rights of the LGBTQ community is the question that we have. And to do this, we have no better person to begin the discussion than the current mandate holder, the independent expert on sexual orientation and gender identity, who is Graeme Reid. And why I say is no better person is because Graeme is at heart someone who's engaged very closely with the question of how we take forward the rights of the community. At the same time, in his previous life, which very much informs the work he's doing now as an academic, he's understood the structures within which this particular work is embedded. So, as both an activist, as a scholar, and currently the mandate holder of sexual orientation gender identity, Graeme is ideally placed to help us make sense of how do we take forward the rights of the LGBTQ community in such a fractured and divided world which is rife with the kinds of inequalities we see, in particular, the inequalities within global north and global south, framed by the legacy of colonialism. So, without further ado, Graeme, I'll leave the floor to you and ask you to again to help us think through this question. How do we take forward this question of the rights of the LGBTQ community in the contemporary context?
Thanks so much, Arvind. And as you say, decriminalization of consensual same-sex conduct is a founding objective of the mandate and an essential component of combating discrimination and violence. Since 1990, 55 countries have decriminalized. Remarkable progress. Whether pursued through penal code reform or strategic litigation, history shows us that such initiatives are most likely to succeed when locally driven, appropriately timed, and grounded in specific political, social, cultural, and legal contexts. International human rights law is settled. Laws prohibiting consensual same-sex conduct violate privacy, and where women are affected, equality and non-discrimination. They are incompatible with human dignity, and detention under them is inherently arbitrary. Yet, lacking a universal enforcement mechanism, international human rights law depends heavily on persuasion grounded in legal principle. And this is why strategic considerations are paramount. Any decriminalization initiative must be considered against a highly polarized global context in which the rights of LGBT people have become a symbolic marker of geopolitical conflict. It's notable that, despite this polarization and pushback, decriminalization has continued at a steady pace in many parts of the world without attracting the same rhetorical baggage. One exception to the broader trend towards decriminalization is emerging in the Sahel. Against a backdrop of growing Russian influence and regional initiatives invoking African sovereignty and family values, across this region, criminalization has been justified by official rhetoric as an assertion of national sovereignty, patriotism, and cultural values. Now, the point is not whether these arguments are factually sound or withstand scrutiny, but that they have acquired considerable resonance and persuasive force by drawing on legitimate historical grievances against former colonial powers. During the colonial period, the so-called civilizing mission portrayed colonized people as sexually licentious and therefore primitive, while imposing European moral and legal norms upon them. Today, sexual liberalism is frequently presented as a marker of modernity, reproducing a hierarchy in which former colonial powers once again claim the authority to define social progress. Now, this history helps explain, without justifying, why external pressure concerning gender and sexuality may be received with suspicion, and why these issues are sometimes evoked as symbols of national sovereignty. As scholar Rahul Rao observes, the use of gender and sexuality in post-colonial nationalist politics is, and I quote, in part a response to the humiliation of colonialism. Recognizing this historical genealogy does not validate contemporary criminalization, but it helps explain why appeals to sovereignty and cultural authenticity can carry such persuasive force. And also why it is essential that decriminalization initiatives are locally owned and driven, and at minimum, this history calls for a measure of humility on the part of former colonial powers when engaging on these issues. Thank you.
For really setting the tone in terms of helping us make sense of the question of the LGBTQ rights question within the broader frame of criminalization, as you put it, the politics of cultural authenticity, to factor that into our work and our activism. Thank you so much. I know that you will not be able to stay for much longer, but we really appreciate the time that you've been able to give us and attend this particular gathering and kick it off in this really wonderful way. Thank you so much for being here. I will now go on to this. We have the second part of our program where we invite activists who are working at the ground level in communities to come and share a little bit of their experience on what is it like or what is it that they've achieved through working on the issue of decriminalization from their country context, as it were. I'll begin by asking Bradley Fortuin to join us and to share his thoughts or their thoughts on the entire question of who's part of the Southern African Litigation Center on the litigation efforts in reducing the harm that criminalization does in your communities. Thanks, Bradley, for being here. Please, the floor is now yours.
Thanks, Arvid, and hello to everyone. Bonjour, tout le monde. I'm trying my French out also. But yeah, just to jump into it, I think from our work at the Southern Africa Litigation Center, what we have learned and discovered also is that there's not a single model that follows decriminalization in Southern Africa. I mean, in Botswana, for example, we've seen constitutional litigation heavily supported by communities, and also through the whole strategic litigation process, Botswana heavily relied on constitutional guarantees to dignity, to equality, to liberty, and to privacy. And this process also, which once again was heavily supported by communities, and Habibo also was also, on the other hand, heavily rooted on Botswana's values of Botho, and also showing that the evolving social context of our traditional context also plays a crucial role in this. In Namibia also, we've seen civil societies and activists develop jurisprudence, by taking a series of cases to challenge before actually challenging the sodomy law. And even after legal success, we saw anti-rights political mobilization intensified through this. And this lesson here also is, as we continue our constitutional jurisprudence, a step-by-step step must be taken to prepare for political and religious backlash, even after our legal victories also. And Angola also is like a different thing. Also, they didn't go to the courts, but they changed their laws through a comprehensive penal code reform, and where civil society was involved, through documentation and engaging with lawmakers. And through this also, we see that legislative reform can succeed where governments are already reviewing outdated legal frameworks, and also on the other hand, working actively with civil society and activists also. And I think key lessons also from all these examples also is, one, how litigation needs to be heavily reflecting the lived realities of those that are affected by it, because it's more than just one person, it's more than two person, but it's a whole community. And community organizations also help in producing evidence, which plays like another crucial role, whether it's around showing discrimination, the impact of policing, healthcare barriers, and even violence and hate speech. Those effects on our lived realities also plays a very crucial role in the courts also. And what we've seen work, especially at the UN level, is that communities' capacities must be strengthened and supported to help in defining our advocacy priorities. So communities must be supported, they must be resourced, and so forth. And something that we used in Botswana also was also, one, congratulating the state on what they've done, progressively, and then also bringing in our issues, our mandates towards them. And some of the risks that we've seen also is governments sometimes also mobilize nationalism and traditionalism, especially around soggy issues and soggy debates as well. And also, if our advocacy is not locally grounded, this also has an impact on international advocacy also, and also somehow strengthens the anti-rights narrative also that comes with oh, this is an African, this is a Western import also. Yeah, and just like a last point also is that highly visible international pressure also can reduce political spaces and engagements for civil societies and activists in country with governments also. So finding that balance between how much do we put out there, especially around international media, international pressure also, but also not causing harm also for civil societies and activists in country also at the same time. Yeah, I think in the interest of time, I shall end there and hand it over back to you, Arvind. Thank you.
Thanks so much, Bradley. Thank you for that really wonderfully brief way of communicating the sense of what communities can do and have done in the Southern African context, and the reason or the need for international actors to understand this dimension of the actually excellent, really wonderful work going on in your part of the world. Thank you so much, Bradley, for your sharing. Now I'll go on to invite Jolene Matale to join us. Jolene is from the Pacific Sexual Gender Diversity Network, and she's from the Kingdom of Tonga. And Jolene, if you're here, it'll be lovely to have you here to share your thoughts on the decriminalization efforts in your part of the world.
Good morning, everyone. Maluelele from the Kingdom of Tonga, and it is a pleasure to be here in this platform to share with you what's happening here in the Kingdom. It's 1:25 a.m. here, and please excuse me if you find my presentation a bit sleepy, but I had to rush from a royal event, just to be here to share with you what's happening here in the Kingdom. In line of our topic of decriminalization, we see community-led human rights advocacy we must drive any decriminalization strategy in Tonga specifically tailored to the cultural, religious, and political realities of the Kingdom. For the Tonga Ladies Association, navigating law reform requires balancing local cultural preservation with global advocacy while mitigating backlash. Here's a strategic framework for decriminalization. Collective action and navigating international mechanisms in the Tongan context. When you contextual decriminalization strategies for Tonga decriminalization in Tonga, we cannot mimic Western frameworks into respect Tongan culture, anga whakatonga, and Christian values. So in sections 136 and 142 of the Criminal Offences Act, which criminalize sodomy and cross-dressing under vacancy definitions, are rarely enforced but remain harmful legal stains. So reframing through the tauhiwa, or the foundational Tongan concept of nurturing relationship, which emphasizes way to protect community members from harm rather than demanding individualistic rights, aligns with traditional values, the health and safety pathway, advocating for law reform through public health data is often less polarizing, pointing out how, punitive laws hinder HIV prevention, and mental health support allows the Tonga Ladies Association to engage with government sectors like the Ministry of Health, targeting on vagrancy law first, and then the law penalizing cross-dressing are often tied to outdated colonial Vagrancy Act. And so lobbying to repeal or amend these specific clauses can be pitched as modernizing archaic colonial era legislations rather than a radical moral shift. So the importance of community leadership, external organizations cannot lead these movements. So the Tonga Ladies Association must remain visible, trusted anchor of the strategy. Cultural legitimacy, ladies hold unique recognized roles in the Tongan society, particularly in pageantry, domestic labor, royal service, and event organization. So capitalizing on position on belonging, not isolation, trusted intermediaries, the Tonga Ladies Association leaders understand the importance of delicate social hierarchies. And they are best equipped to hold quiet, respectful dialogues, Talanoa methodology with traditional leaders, noble families, and clergy, in avoiding public confrontations that shut down progress. Protection against Western import accusations when local leaders front the movement, it disarms conservative critics who claimed the LGBTIQ plus rights are a form of Western neo-colonialism, invading Tonga. So UN strategy and collective action, engaging with the United Nations, provides vital leverage, but it must be calculated and collective. So universal periodic review, leverage, the Tonga Ladies Association should always continue the collaborating with regional bodies like Pacific Sexual Gender Diversity Network to submit shadow reports to Tonga's UPR cycles. When we talk about collective Blue Pacific voice, Tonga responds better to regional solidarity than global pressure. Aligning with activists in Fiji, Samoa, and the Cook Islands, which successfully decriminalized same-sex relationships. And it creates a Pacific-led narrative, of a progress. So sovereignty first language, the UN engagement should emphasize that Tonga is fulfilling its existing commitments under ratified treaties like the Convention of Rights of the Child or CEDAW, rather than adopting entirely new unratified global mandates. The dangers of UN resolutions in the Tongan context. While international pressure can be useful, pushing for heavy-handed UN resolutions or public condemnations of Tonga carries severe domestic risks, and the backlash effect is very aggressive. Top-down UN resolutions censoring Tonga can trigger a defensive hyper-nationalist response. However, government officials and church leaders may double down on punitive laws to signal resistance against foreign interference. Weaponization by religious conservatives. Hardline religious groups can use sweeping UN resolutions as proof that global entities are trying to dismantle Tongan sovereignty and Christian identity, leading to increased public hostility, physical unsafety for the Leti community, and of course, erasure of nuance, which broadly worded UN resolutions often fail to capture the unique, paradoxically accepted social position that Letis hold in Tonga despite the legal framework. So forcing a rigid legal binary from New York or Geneva can shatter the fragile social peace that is currently enjoyed locally. Malo Abito.
Thank you so much, Jolene. We've gone from the Southern African context to looking at the Pacific context, and Jolene has really communicated what does it mean to do advocacy using the cultural resources one has. How do you challenge, in a sense, the narrative that you're not of this particular country, that decriminalization is not your agenda, and what are the nuanced ways in which you can take your activism forward? And there's a resonance with Bradley's presentation, but thank you so much, Jolene, for that really wonderful sharing. I will now move on to inviting Dane Lewis to join us now. Dane is from the Carrie Flags, Jamaica, and he will share his experiences on what they've been doing on decriminalization in another part of the world, which is the Caribbean.
Thanks, Arvin. We have we've been at this a little while. I think I joined the movement 20 years ago, and we began the first case, being strategic about what we would bring. Those discussions began just around that time, even though the first case was won in 2016. Some of the key learnings that we've had is that we've had to ensure that anything that's based on litigation is locally owned. It's a locally owned agenda. It's driven by local people. Caribbean lawyers show up and represent all the claimants. Across the region, we've employed multiple strategies, and key amongst them, communication and safety and security are key components that we've ensured that we had to engage. One of the things that we, certainly in the most recent cases, benefited from during COVID was the ability to limit communication. That was also to help reduce the likelihood of the anti-rights groups taking on any messaging and creating any disinformation. And certainly we know there are instances where it's strategic to either lay low or say nothing, and there are other times we figured when it is useful to be visible. The other bit is, and certainly has worked in the smaller territories, the ways that we're able to engage governments through dialogue rather than confrontation, seizing any opportunity to present what the real ask is of the community. We've also been investing in community leadership over the past few years so that the community, not just the advocates and the leaders can speak, but that the community can understand what the cases are about and how we go about it. And I think Bradley raised one key bit, that we're also documenting the instances of violence and discrimination. I think one of the key strategies that's also helping us move forward is this idea of building coalitions. What does real allyship look like? And we recognize that building coalitions is going to take us further, recognizing human dignity extends way beyond the issues of the LGBT community. But grounding all of this, though, Arvin, has been the key bit. I think that we've all been saying that the litigation can only happen if the community wants to engage in it. And so we are led by community in terms of when are we ready to take a case forward. Certainly we have to be careful about the ideas of neocolonialism has been raised by our previous speakers. And so I want to jump to how can the UN support? I think there are some key ways First, trust the local leadership and local voices. I think it's been said before, so we ask that they listen to community. Second, fund our movements. We know that governments are reducing overseas development aid, and we've seen what that withdrawal of aid has looked like in terms of the ability of our communities to sustain change. What we're asking is to make meaningful investments in our movements. Thirdly, just continue the advocacy that you do in the halls of the UN. Use the UPR mechanisms, etc. You know, some of that quiet advocacy in the halls. Continue. And then, as has been said before, ensure that anything that is being developed should be developed through meaningful consultation. Engage local civil society. The phrase "nothing about us without us" is what I want to leave with us. Thank you.
Thanks, Dean, for reinforcing the point made by both Bradley and Jolene, which is the idea of community-led leadership, the idea of dialogue, not confrontation, the idea of intersectional or coalitional work. Thank you so much for your work and for the presentation today. I'd now like to invite Weema Askri from Mawjoudin, Tunisia, to come and present their work. I don't think Weema is able to make it because of, again, this is where you realize the global north, global south related challenges, because challenges with respect to access. And so on their behalf, Yahya will read out a note which Weema had prepared. Thanks, Yahya.
Yes, thank you, Arvin. So our colleague Weema from Tunisia was due to deliver this intervention. Unfortunately, she is unable to join us because of the electricity outage. So I have the honor of delivering their remarks on their behalf. So I'm speaking today from Tunisia, where LGBTIQ+ communities continue to organize, advocate, and care for one another, despite an increasingly restrictive environment for civil society. Article 230 of the Tunisian Penal Code still criminalizes consensual same-sex sexual relations, carrying prison sentences of up to 3 years. Beyond the law itself, criminalization legitimizes discrimination, creates fear, and reinforces the idea that LGBTI+ people do not deserve equal rights or protection. Civil society faces growing restrictions, and organizations working on gender, sexuality, and human rights are frequently portrayed as promoting foreign agendas. This rhetoric not only undermines our work, but also puts activists and community members at greater risk. It affects every aspect of life. It discourages people from reporting violence, seeking healthcare, or assessing justice. It forces many to hide their identities, limit freedom of association, and creates constant uncertainty for those simply trying to live openly and safely. This is why discussions about decriminalization at the international level are so important, but also why they must be approached with care. We need states to speak out, to raise concerns in diplomatic spaces, to support human rights defenders, and to invest in grassroots organization. But solidarity is most effective when it is guided by those living the realities of criminalization every day. Strategies that are effective in one context may unintentionally place communities at greater risk in another. As anti-rights narrative increasingly frame LGBTIQ+ rights as a foreign or Western agenda, international initiatives that are developed without meaningful consultation can sometimes reinforce those narratives instead of advancing our shared goals. It means involving local movement from the very beginning, listening to our analysis, respecting our assessments of risk, and trusting communities to define what solidarity should look like. If I could leave you with 3 messages today, they would be these. First, support communities' leadership. Those most affected by criminalization should shape the strategies designed to the end of it. Second, invest in movement, not only momently. Sustainable funding for organization, legal support, well-being, security, and organizational resilience is just as important as high-level advocacy. Success is measured by whether people become safer, freer, and more able to organize, speak, and live with dignity. It is about creating the conditions in which people can participate fully in society without fear. That future can only be built in partnership with the communities whose lives are most directly affected. Thank you.
Thanks, Yahya, for that eloquent reading of Weema's presentation. But I'd just like to only reiterate the point that the reason Weema is not here links up closely to the mandate of the independent expert, which is human rights are interrelated and indivisible. And there are challenges that people from the global south face in participating forums, which are actually global forums. So we have even greater responsibility to listen to those voices very closely. And Tunisia is going through a particularly difficult time, we gathered. And I think that story, for those who don't know, will be worth paying greater attention to by maybe conversations with Weema after this event as well, if we can circulate Weema's details for people who might be interested. Thank you so much, Yahya, for this for putting forward the Weema's presentation. The next part of our event, we're moving from the completely local to looking at the advocacy at the UN level. And I'd like to invite Tess McCoy from the ISHR, International Service for Human Rights, to speak a little bit about strategies and collective action at the United Nations, which is the level. Suddenly we've jumped the level from the completely local to the international. So Tess, the floor is now yours.
Thank you, Arvind. It's an honor to be part of this panel. I have worked on LGBTQI issues at the UN for over a decade with the International Service for Human Rights. It's an organization that promotes the rights of human rights defenders and is committed to being guided by them. I want to start by acknowledging those who built the foundations we stand on, the queer activists and communities who came before us, many at great personal risk. Since the first resolution was withdrawn in 2004, we have made huge progress at the UN. A succession of joint statements, the first in 2006, laid the ground for the Council to adopt the first ever resolution on sexual orientation and gender identity in 2011. A second in 2014, built towards the creation of the mandate of the independent expert in 2016, now renewed 3 times. Alongside this, the treaty bodies built the legal basis advocates drew on, and the UPR and special procedures applied it through recommendations. Each step was deliberate, called for by queer communities, and carried forward in collaboration with supportive states. Each advance was also contested. The opposition organised in response, and the wins exposed a rift. That rift has hardened, with blocs becoming predictable and many positions entrenched. Our context currently is complicated. Democratic erosion and backsliding, anti-gender actors more organised and vocal, resolutions on unrelated issues becoming battlegrounds over references to gender, and many global North states struggling with their own credibility. So the question I would put is this: how do we build support from states, including those who reject these rights? Progress at the UN has been deliberately gradual, achieved through framings that connect across difference, by building on universal norms such as protection from violence and discrimination and access to health. Any initiative that deepens that divide risks working against the agenda as a whole. Let me be clear, criminalization is a human rights violation, and decriminalization is a human rights imperative. But the current context matters for how we move from legal standard to political recognition and implementation. We are not against ambition or against votes. On many files at the UN, we urge states to be bold rather than settle for consensus, particularly on new initiatives. But resolutions on sexual orientation and gender identity sit differently. They always go to a vote, and tabling one spends finite political capital defending ground we already hold in part. For example, the 2022 mandate renewal condemned criminalising laws. Resolutions can risk putting language we have and everything we've built before it back into negotiation, and with new language open to hostile amendments. Votes can also carry costs. A vote that fails or passes narrowly hands opponents a result to cite and locks states voting against it into defending that position at home. As has been discussed, the colonial history of criminalising laws matters. Global South leadership has been a deliberate strategy at the UN. An initiative seen to originate in the global North opens criticism that LGBTQ rights are imported, and undercuts the legitimacy and ownership that decades of careful work has secured. As you have heard today, decriminalisation is advancing, especially from when led from within. Our job is to resource and protect that work and the defenders at risk for it. Any initiative at the UN must be grounded in calls of queer communities in criminalising contexts, those best placed to judge risks and those who will live with the consequences. Meaningful consultation is asking communities whether and how an initiative should proceed. There are a range of views across our movements, and the question I ask of any initiative is it strategic? Is it cross-regional and Global South-led? Does it do no harm, and does it narrow the division between states or widen it? Ultimately, what matters is whether communities living under criminalisation are safer, stronger, and better resourced, and are able to secure change on their own terms. Thank you.
Thanks so much, Tess, for that really fantastic presentation, which communicated the imperative of consultation, both at the normative level as well as a deeply pragmatic level. Your pragmatic point is that's the way resolutions have always happened. Any change has happened when you had leadership, as it is from the Global South. At the normative level, again, it's really wonderful to see, again, a voice from the Global North saying very clearly that we want to acknowledge and work with voices from the Global South, and we want to be led by the organizations at the ground level. So we really appreciate that normative commitment which the three organizations here have shown, as well as the pragmatics of the whole thing, saying you can't make any change, you can't make progress if it doesn't come from the bottom up. Thank you so much, Tess, for your presentation. Now we'll go to the last presentation is by Venus Aves from Outright International. And Venus will take us a little bit through one of the histories we don't know much about, which is the history of colonialism and the French territories and the former French colonies. Thank you. Venus, please go ahead.
Thank you so much, Arvin. Hello, everyone. Bonjour à tous et à toutes. I think in one way or another, everyone in this room today already knows that homophobia is a colonial legacy imposed by European colonizers. But I think what Outright International's recent map shows is the breadth of this reality. Next slide, please. We found that 4 out of 5, or 80% of all countries that criminalize consensual same-sex sexual acts inherited these laws from colonial rule. That is 52 out of 65 countries. And I think Britain's role is well documented. Former Prime Minister Theresa May apologized for spreading homophobic laws in 2018. But the role of France has gone largely unexamined. Next slide, please. And I think the dominant narrative is that since France was the first Western European country to decriminalize sodomy in 1791, it did not leave criminalizing laws in its colonies. But that is not true, and it misunderstands how the mechanisms of colonial imposition in place in former French colonies, mandates, and protectorates. Next slide, please. So while, for example, the 1810 Napoleonic Penal Code did not criminalize sodomy or homosexuality, it did criminalize public indecency, which was disproportionately enforced against sexual minorities. And in 1942, under occupation, the Nazi-allied Vichy regime set a higher age of consent for same-sex sexual acts, therefore criminalizing same-sex sexual acts for adults between the ages of 18 and 21. And in 1960, France amended Article 330 to create harsher penalties for, and I quote, acts against nature with a person of the same sex. Next slide, please. And this legacy is alive in at least 11 countries today, from Africa to former French overseas territories. Next slide, please. And the situation in Maghreb, I think, clearly demonstrates this colonial legacy. For example, in Tunisia, it was a commission set up by the French, largely composed of French officials, that drafted the 1913 Penal Code that criminalizes sodomy. And this penal code, this provision, remain in force today. In Morocco, it was a decree in 1953 promulgated by the French Resident General that criminalized public indecency and sodomy. Post-independence, the penal code mirrors this language. In Algeria, which was ruled as multiple departments of France until the hard-won independence in 1962, French metropolitan law applied. Therefore, Article 330, and as amended in 1960, which criminalized acts against nature with a person of the same sex, directly applied in Algeria. Post-independence, the 1966 Penal Code directly retains this language. Next slide, please. In at least 5 other former French colonies, mandates, and protectorates, the language used is of indecent or unnatural acts with a person of the same sex. Specifically, in these 5 countries, Comoros, Guinea, Mali, Mauritania, and Togo, French metropolitan law directly applied from 1946 until independence, when a decree transferred jurisprudence over criminal cases from indigenous courts to French courts. Next slide, please. Now, what are we trying to say? We're not saying that French colonial history prevents them from taking an active role in our global fight for decriminalization. What we're saying is that France cannot meaningfully lead any global initiative for LGBTIQ people's rights without recognizing and apologizing for its homophobic colonial legacy, in the same way that the UK did in 2018. We're saying that a global initiative for decriminalization will not be meaningful without funding for Francophone movements, which are among the most underfunded in the world. They currently receive under 1% of all LGBTIQ funding in an area inhabited by 5% of the world's population. And finally, to break the cycle of colonialism, we believe that all states should listen to communities before they take action in any multilateral fora. And you can access, you can learn more about French colonial homophobic legacy by accessing our new article, and I'm sending the link to this article below. And we hope that France will take this insights meaningfully and constructively and ensure that any action in the UN by any state will not cause any harm to our communities. Thank you. Merci.
Thanks, Venus, for that presentation, and in particular for shedding light on the under little known historical context of how France has been complicit in terms of the spreading of anti-sodomy laws throughout the former French colonies. And in particular, thank you for bringing up the entire question of apology. We have not often thought of the question of apology in the context of LGBTQ rights. And the point you're making is, sure, if you're a country with a colonial legacy, which is responsible for these laws, you begin by acknowledging your role in perpetrating that kind of violence and think of some form of a reparation for the violence that you have caused. And that's a starting point in moving forward a resolution of this nature. So there's also a way in which you're saying that a personal acknowledgement or acknowledgement on behalf of a country is a very, very important starting point for debates of this nature. Thank you so much, Venus, for your presentation. And just a quick couple of points to bring together all the presentations. I thought we had a brilliant start by Graeme, where he brought in the entire question of colonialism and the role of colonialism in the entire question of the anti-sodomy laws, as it were. And from there, we had a sense of the grassroots level assertion or grassroots level thinking, or groups from the from the African context as well as the Caribbean and the Pacific, and if you take mind the Indian context, the case we're all making is that the litigation, decriminalization needs to be grassroots-led process or a movement from the bottom to the top, as it were. And finally we got from the looking at the range of nuanced grassroots level presentations to looking at the work of the United Nations. And you join me in saying that the presentations, which were about the work of the UN, showed a similar sensitivity and nuance as the grassroots level presentations. They seem to be informed as well by the work with communities and the work at the grassroots level. And that is why the entire question of a resolution at the UN is something which has really emerged in the past from community level advocacy, consultation, and discussion. It's benefited enormously from those discussions. I'll just give you one example from the past, which I remember. When South Africa was moving its resolution, the discussion at that time was, would Germany be prepared to move that resolution? And I remember the German ambassador making the point that German advocacy, as far as this resolution was concerned, would be the kiss of death. And his point was simply this: as former colonial powers, we have too much blood on our hands, and we can't be the ones fronting these forms of resolution, though we might be completely supportive of it. And as Tess indicated, the history since then has been a history of global South-led advocacy. If it's the South Africa-led resolution, if it's the resolution on the IE SOGI led by the Latin American countries, including Chile, Argentina, Brazil, Uruguay, Colombia, we've seen the very, very significant and important role that the Global South has played. And we've also seen how, over a period of time, the advocacy has resulted in more and more countries from the Global South taking on a supportive role as far as these issues are concerned. In the Asian context, we've seen Vietnam, who's emerged as an important figure. We've seen the attack on Japan and Korea, who've been very important. We've seen Sri Lanka, Nepal abstaining and showing, in that sense, some level of support as well. So there's a way in which this issue has become more and more, in my estimation, owned by the Global South. In particular, I'm sure if you look at the range of organizations over there on this list who are attending this website, we'll find a large number of them, maybe a large majority of them, are really from the Global South. So the key stakeholders are really from the Global South. And if the key stakeholders are from the Global South, surely, our presenters are saying, surely we must pay heed to these voices. Surely our advocacy must be informed by these voices, just at that level itself. And secondly, the lesson of history. All our successes have been won when the leadership has been shown by Global South countries and Global South organizations. And it's very, very important that we pay heed to that history in any advocacy efforts we have going forward. With those few words, now we'll open it, I think, to the audience for any comments, thoughts you might have to share, either in terms of your what thoughts you have or questions you might have to any of our wonderful panelists. Yeah, Daniel, please go ahead.
I would like just quickly also, Arvind, to add one important detail. So yeah, if your organization believes that decriminalization must be community-led, grounded in meaningful consultation and guided by the principle of do no harm, we invite you to join our growing global coalition of more. Sign our joint statement calling for any future UN initiative on decriminalization to be developed with and not for the communities most directly affected. Together, we can ensure that the international advocacy strengthens local movements and advances lasting change. So I'm sharing the link here on the chat. Please feel free to sign it and share it widely. And thank you, Arvind. Voilà. You have it on the chat. We will leave it here for about 2 minutes so that everyone can have access to it. Arvind, would you take a question or two, maybe?
Yes, yes. I think we'd opened it, right? I mean, are there any questions there?
Let's check.
Yeah, I think we have okay, 5 questions from Emeka from Nigeria, and 1 from an anonymous attendee. Okay. Do all our speakers have access to these questions, Yahya?
Yeah, please go ahead.
Okay. If our speakers have access to the questions, maybe we'll just take 1 question from Emeka, and I'll just read out the 1 question, and if any of our speakers would like to address it, that'd be great. What lessons have been learned from countries where community-led decriminalization has successfully influenced legal reform? Rather Dane,
Bradley?
Doreen,
Oh yeah,
Bradley?
go Bradley, I think.
Yeah, Bradley, could you share the experience of SALC in the different Southern African countries, whether Mozambique, Angola, your own experience with Botswana, maybe, or Mauritius? Please go ahead.
Yes, I'm just quickly trying to go to the question. Yeah, okay. Yeah, I mean, I think I'll still go back to what I had said before also, on how what was done in Botswana. So first of all, in terms of gathering evidence also, communities were at the center of that. We had sessions where if it was like community engagements, gatherings, where we had Q&As, what do you call it? Yeah, surveys where people answered questions, and these were analyzed to also show to also show how the lived realities of LGBTIQ people are, right? So that's one on how communities have led and actively supported the whole decriminalization process, even in terms of working with allies, because I think allies also form part of our communities. We saw our parents, our aunts, our older generation. I was still pretty young then. Get on buses, traveling from all 4 countries, 4 corners of the countries to come to court, to show that visibility. And I think the fact that the bench also saw that actually, these are not just people from the city, but there's like a wide range of people who are supporting them, who are standing with them, who are part of their community. Our community actually. So we had religious communities show us. I don't know what the right word is. Yeah. We had our parents there in the traditional outfits. We had queer communities there actively in the rainbow colors. And everyone was there with one voice, one message. There was no separation in communities, but people stood together. And I think that's one of the things also that as we're talking about decriminalization being led by communities and that aspect of strengthening communities, because we've been through so much, we've been disempowered, we've been dispirited, demembered as communities. It's time to go back also to that essence of what does community stand for and what are we standing for as a community, as a movement. And even if it's issues around accountability, that needs to be discussed also, because as much as it reminds me of one of the quotes from from the cases in Botswana where the judge actually said we might have won this case in court, but there's also still the other battle out there, which is like changing hearts and minds of communities, you know. So that's something else also that we need to figure out in terms of our messaging, and yeah, just going back to basics.
Thanks.
Yeah.
Thanks,
Yeah.
Bradley. I think we don't have that much of time, but one last question we'll ask Tess. Tess, the question which we have for you is, given the anti-rights and anti-gender actors increasing at the UN and other multilateral spaces, what are the risks of a new resolution on decriminalization in the multilateral spaces?
Thanks, Arvind. Yeah, I alluded to this a little bit when I was speaking, when I was talking about the current context. So, I mean, we know that the context has always been difficult for moving these issues through the UN, and we have, as I was speaking about, we've made a lot of progress, and that progress has been because we were strategic, because we were deliberate, because we built on previous wins, and because we connected and consulted and worked together collaboratively, and we're Global South led. And we're currently in a specific context, you know, and I think the anti-rights actors is really critical to that. We have the anti-rights actors that are more vocal, willing to speak out, and better funded in a moment when we're all struggling, and especially national and local organizations are struggling for funding. We're seeing anti-rights actors are increasing in funding. And that is impacting and shifting the dynamics that we're seeing at the UN. And so it does mean that there are risks around any resolution at the moment, and especially one that would reference decriminalization or reference sexual orientation and gender identity. I mean, it's to the point where we're seeing resolutions that are not actually on these issues, that are on totally separate issues, where a reference to SOGI, but most often even references just to gender, that becomes a battleground then. And this polarization that I was talking about, this rift between two different sides, is playing out in resolutions that don't really have anything to do with these issues. So it's really, really critical to think about that when we're thinking about initiatives, that space at the ground and the context in which we're operating at the UN. It means that language that we have won over the years that has been slow and intentional is at risk of being lost, is at risk of hostile amendments. Any new language that we might seek to gain in a resolution is also at risk of not making it into the final resolution, or again, hostile amendments or being deleted. And so as I said earlier, a resolution will be voted out. These issues are always voted. And so then the impact of that vote, if it's a close vote, also has carry-on impacts both at the UN and at the national context, depending on whether a state voted for and against. So it's a really good question, and thank you for the opportunity to build on my statement a little bit more, to bring that into the discussion. Thank you.
Thank you. We've had I think a range of other questions, all of which I'd really love to answer, but I think we've really run out of time. So I'd just like to end by thanking everybody, all the speakers, for really wonderful presentations. And thanks also to the audience. I mean, we have 80+ people who have been here, and obviously very passionate and very engaged, going by the range of responses we've got on the chat. And we really want to continue with this form of engagement, this form of discussions, because we learn through discussions of this nature, between the global and the national and the regional. How learning happens is through discussions. And so it's very, very important we continue these discussions. And on that point, on August 11th, we will be having another webinar, and the details of that will be publicized soon. The statement as well, which follows in a sense of which the sense of what we talked about today is crystallized in the statement to the French president on the question of not moving this particular resolution at this particular moment in time. If you haven't signed that statement, please do look at the statement, and if you think that it makes sense, please do consider signing it. Thank you again to everybody, and have a good morning, good evening, or good night, as the case may be. Thank you so much.